Now, today we are going to be talking about an appeal being made to the Supreme Court by the federal government in a case called U.S. v. Rahimi. Now, this is a case that has come out of the Fifth Circuit Court of Appeals, which essentially, based on their opinion, validates the prohibition that individuals that have been convicted or are subject to a domestic violence restraining order cannot be in possession of a firearm. The Fifth Circuit Court of Appeals essentially makes the argument that is outside the scope of a Bruin analysis. Now, as you can imagine, both the federal government as well as a number of state governments are deeply troubled by this, and they are appealing to the Supreme Court and trying to get what's called a writ of certiorari, trying to get the Supreme Court to decide to hear the case, which candidly, they probably will. In this video, we're going to be talking about not only the arguments made in their petition for the writ of cert, but also in the underlying case, and what types of implications this will have, not only for those individuals who now suffer a lifetime ban based on a finding a misdemeanor of domestic violence, but also for potentially red flag laws, which also sort of countrywide might be construed, depending on how this ruling goes, as being in violation of the Constitution. So, to begin with, let's talk about the actual defendant in this case, Mr. Rahimi. Mr. Rahimi is not in jeopardy of ever getting an award for being a virtuous citizen. In both the underlying case as well as the petition for cert, they go through the litany of some of the egregious conduct that Mr. Rahimi has been engaged in over the years. Everything's from narcotic trafficking to shooting at vehicles to being involved in road rage incidents. The guy has some underlying problems, okay? But apparently, at the time that he was given the restraining order for domestic violence, there was nothing in his background that actually created a prohibited person status other than this restraining order. So he's ultimately arrested for, once again, being involved in nefarious conduct. He happens to have a firearm on him at the time. There is this restraining order in place. He is therefore now prosecuted under federal law of 922G8. This is part of the U.S. Code that essentially says that anyone who's subject to a restraining order or who has been found guilty or pled guilty to the crime of misdemeanor domestic violence is prohibited from being in possession of a firearm. Now, once we've actually gotten to the level of having a criminal proceeding, that creates a prohibition for life. That's referred to as the Lautenberg statute. We're not actually talking about Lautenberg right now. We're talking about the precursor that comes with simply a restraining order being issued in a civil forum. Okay, this hasn't gotten to the level of going through criminal trials. It's simply a judge handing out a restraining order saying that the restrained person cannot be in possession of a firearm. This creates that sort of prohibitive person status. Well, the Fifth Circuit Court of Appeals, in a post-Bruin environment, looked at this and said, this is going to be unconstitutional. So this video is being sponsored by USCCA, and they're doing a giveaway right now. Now, the details are going to be listed in the description below this video. I encourage you to take a look at them. It's really cool. It does end soon. I'll give you a hint. What they're giving away, it can fit in your holster. You know, one of the arguments, and this is really instructive, one of the arguments that the state makes in their, attempt to keep the conviction for Mr. Rahimi at the Fifth Circuit level is that the Second Amendment simply does not apply to him. Remember from our discussions on the Bruin analysis, the first step in making a determination as to whether or not the Second Amendment even applies is for the plaintiff, in this particular case it would be Mr. Rahimi, to argue that the conduct is protected by the Second Amendment. Once he has satisfied that, the burden then shifts to the state, where the state has to explain how the regulations are consistent with our nation's history, text, and traditions of firearms regulations, specifically at the time of the ratification. So during the initial phase, the step one phase, for lack of a better way of saying it, the state argues that Mr. Rahimi is simply not protected by the Second Amendment because the Second Amendment only protects lawful citizens, individuals that are not criminals. Ergo, if you are a criminal, you fall outside the scope of the people that the Second Amendment articulates. As you remember in reading the Second Amendment, a well-regulated militia being necessary for the security of a free state, the rights of the people to keep and bear arms shall not be infringed. So who are the people? Well, the state has been very kind of amorphous as to who the people are in a number of different court cases. In this particular one, though, they specifically are saying the people are only law-abiding citizens, and Mr. Rahimi is anything but. Here's the problem. At the time that Mr. Rahimi was given the protective order preventing him from being in possession of firearms, he was actually a lawful citizen, at least lawful to the extent that there was nothing in his background. He had a number of misdemeanors behind him, but there was nothing in his background that would have prohibited him from being in possession of a firearm, but for this protective order. Now, that's also very interesting because in the concurring opinion, one of the arguments that Judge Ho of the Fifth Circuit makes is that a civil order is nothing more than a civil order. It's not a criminal proceeding. It's a civil proceeding. And in this particular context, it's a civil proceeding in family law. And judges are very, very liberal in issuing protective orders. They don't see it as a tremendous burden on somebody's constitutional rights. And in fact, oftentimes, protective orders are used as a strategy in sort of pre-divorce litigation. Well, as a result of that, you could have somebody who loses a constitutional right, albeit for a period of time, simply because of civil strategy on the part of another spouse. What's also interesting is that in many, many cases, judges will issue mutual protective orders. Essentially, he will restrain both parties. Well, if that's the case, you have a spouse that might legitimately be a victim of domestic violence, and now you have that judge essentially restraining that person from being in possession of firearms to protect themselves against the abuser. So there's a real problem associated with this. You know, the ability for the state to infringe on a right is going to end up having to require a massive level of deference and care and an extraordinarily high burden. And that's usually done in a criminal trial where the standard of review is beyond a reasonable doubt. Keep in mind that in a civil setting, it's simply a preponderance of the evidence. It's a far lesser standard. So in the concurring opinion, Judge Ho is deeply concerned about this. In the original opinion, the majority of the court says, you know, you're making this argument, state, about about a law-abiding citizen only being the ones that the Second Amendment applies to, but you sort of are arbitrarily limiting your analysis to protective orders. Why? I mean, there's nothing in your argument that would preclude also saying anyone who gets a speeding ticket is precluded from being in possession of a firearm, or anyone who, is engaged in some sort of political rally is prohibited from owning a firearm. So they essentially extrapolate out the natural folly of this whole thing. Now, as I mentioned in our Bruin analysis, once we've made the determination that the Second Amendment does apply, then the burden shifts over to the state so that the state can explain how the burden is consistent with the history, text, and tradition of firearms regulations. Now, here things get a little interesting, and it's not so much on the Fifth Circuit's opinion. It's actually on the state's appeal to the Supreme Court. What the state is arguing, and to a very, very limited extent, they're correct on this. They say, look, the Fifth Circuit was looking for a historical twin. There was this law that existed at the time of the ratification, which is identical to what we have today as it revolves around protective orders. Therefore, since there was a regulated type of firearms law at the time of the ratification, it would survive today. All right. And that Bruin doesn't say that it has to be a historical twin, all right, that it can be analogous to the firearms regulations that existed at the time of the ratification. And the state always likes to pull up part of a sentence, and this is what I was referring to. They like to pull up this part of the sentence in the original Bruin opinion where they say this should not be construed as a regulatory straitjacket. All right, essentially making the argument to the court that's listening, hey, listen, the Supreme Court didn't say it has to be exact. That being said, you need to read the entire quote from Bruin. It says this should not be construed as a regulatory straitjacket, nor should it be construed as a regulatory blank check. All right, that's an important thing, right? You don't have to have it identical, but you don't have free will to go ahead and do whatever you want here either. There has to be some direct connection, and nothing like that exists at the time of the ratification. Now, like I said, if this goes before the Supremes, they very well could, and I think being logically consistent probably will, say that no, an emergency protective order in a civil setting is not going to be sufficient in order to remove somebody's specifically enumerated civil rights. But more importantly, this now, like I said, goes into red flag laws and might very well invalidate red flag laws, especially if they are adjudicated within a civil setting. It would need to have some level of criminal overwatch for a court to actually sit there and say, all right, defendant, you're being charged with engaging in this particular conduct. Let's provide evidence and everything else to make a determination as to whether or not you are in fact guilty beyond a reasonable doubt. As a little pro tip, we are not allowed to create laws that punish you for the potentiality of future crimes, okay? That's literally prior restraint. We don't do that. So just because on a criminal level there appears as though you may be preparing to engage in some sort of criminal conduct, you actually have to take certain steps in furtherance of that conduct. You don't have to actually do it, but you have to take some preparatory steps before you can actually be charged with that crime. So in any event, like I said, they've sent this over to the Supreme Court. We'll see how the Supreme Court responds. But the Rahimi case is indeed going to be a big one. As always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.
Before you go, you just missed one of our best videos that got over 500,000 views. Click right here to watch it now.